The Supreme Court has dismissed the appeal case on the Building Bridges Initiative, ruling that the Constitution of Kenya Amendment Bill 2020 remains unconstitutional.
Well, the 5 judges on the Apex Court ruled that the President cannot initiate a popular initiative bill, whereas 2 judges in dissenting ruled that the President did not initiate the Constitutional Amendment Bill 2020. All the judges, however, agreed in their verdict that the President is protected by the Constitution and cannot be sued while in office. Benson Chumba has the report.
In a 1,500-page judgment, the 7-judge bench of the Apex Court dissected 7 areas of determination in the appeal by the Attorney General. 5 out of 7 judges reaching a conclusion that the President cannot initiate a popular amendment of the Constitution.
The President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the 2 co-chairpersons when it was too late in the day and beyond recall.
I find it difficult to distance the President from the involvement and the initiation of the popular initiative.
We cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he's also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest.
However, Justices Isaac Lenaola and Joaquin Dungu, in dissenting, ruled that the President did not initiate the Constitutional Amendment Bill 2020.
It is therefore my conclusion that the promoters referred to in this bill are Dennis Waweru and Junet Mohammed. The record speaks for itself.
That process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the President. And therefore, on that narrow issue, I have disagreed with the Chief Justice.
The Supreme Court set aside the ruling by both the High Court and Appellate Court, which found the basic structure doctrine applicable in Kenya.
The extent that the basic structure doctrine limits the amendment power, contrary to the express terms of Chapter 16 of the Constitution, it does not apply to the Constitution of Kenya.
In addressing the President's immunity, all the 7 judges said the President remains protected by the Constitution and therefore cannot be sued while in office. It was a reprieve for the Independent Electoral and Boundaries Commission, IEBC, after majority of the judges clarified that IEBC was properly constituted and had minimum quorum when it processed the BBI bill and forwarded it to the county assemblies.
There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by Parliament despite the standing orders, the receipt of the bill by the President. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary.
Majority of the judges further found there was sufficient public participation in the BBI Constitution amendment process, save for the addition of the 2nd schedule on the creation of 70 new constituencies, which was a late addition in the amendment bill. The verdict coming as Chief Justice Martha Koome issued a stern warning against advocates using social media to attempt to influence judgment of the courts.
This unfortunate practice is emerging, and unless it is checked, it will erode the confidence and the dignity of the courts.
After 2 years of a legal battle between the promoters of the BBI initiative and those opposed to the change of the Constitution, the 7-judge bench led by Chief Justice Martha Koome has put the matter to rest, saying the President cannot initiate an amendment of the Constitution. Ben Chumba, Prime Edition.